Good evening, ladies and gentlemen, and welcome to the Code Enforcement Board meeting. At this time, if you're able to, I would like everyone to please stand, and we can say the Pledge of Allegiance to the flag, and then we'll have a moment's silence. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. Please be seated. Ray, would you like to? Yes, please.
Member Mikowski. Member Mikowski.
Here.
Member Kilburn.
Member Kilburn.
Member Kennelly.
Here.
Member Kennelly.
Here.
Chair Camps.
Here.
Member Cornett. And
Here.
Evan Fricasso and Sony Fernolles is not present.
Okay, thank you very much. At this time, we need to approve the minutes. Has everyone went over the minutes? Are there any objections?
I have one correction. I was also sworn in at that meeting. It doesn't indicate that in the minutes.
I'll make that correction.
Okay. Do I have a motion to pass with the amendment to the minutes?
I'll make the motion to pass the minutes with the correction.
All in favor?
Aye.
Motion passed. Okay. At this time, I'd like to welcome everyone here tonight to the November 17th, 2025 City of Clermont Code Enforcement Board meeting. Before we begin, I would like to advise everyone about the procedures that govern the appearances before this board. This meeting is open to the public under Florida government and the Sunshine Law and is being recorded on YouTube. The Code Enforcement Board is acting in a quasi-judicial capacity when considering individual cases. However, every effort will be made to hear all persons having relevant evidence or argument to offer in accordance with rules for such proceedings. We ask that each person who speaks before the Code Enforcement Board sign the sign-in sheet located at the table up front. After the opening remarks, all those who intend to speak today will be sworn in or affirmed when asked if a respondent is present for your case. Please come up to the podium. All proceedings before this board are electronically recorded. Please speak directly into the microphone at the podium and state your name and address clearly for the record. Additionally, please limit your comments to only information relating to the case being presented. The City of Clermont has the burden of providing a violation exists. The city presents their case, and then the respondent presents theirs. Once all cases where respondents are present have been heard, the board will then hear the remaining cases. Each party may question witnesses offered on behalf of the other party. Additionally, the board members and their attorney may question those appearing before the board. This board will then make its decision based upon the evidence and testimony presented by both parties. The board's role is to determine if a violation exists, and, if so, in most cases, set a date for the violation to be corrected and set a fine if compliance is not met. It is not the board's role to advise you of a specific method or act that you can take to come into compliance. The Code Enforcement Board is appointed by the City of Clermont to review alleged violations of the City of Clermont Code of Ordinance fairly and objectively. Its members are volunteers and not employees of the city. The board's authority is limited to determining if a violation of the code exists. It does not have the authority to change the codes or ordinance. Although you may have evidence, argument, or circumstances that could justify being excused from compliance with the applicable code, you are advised that this board does not have the authority to grant you an excuse. Such an excuse is commonly referred to as a variance or exemption, and may be granted through other procedures such as applications to the city, but not by this code enforcement board. To avoid interference with cases being presented to the board, all cell phones are to be turned off or silenced while in the chambers. And I also would like to remind everyone here on the board to please make sure that your microphone is on during this proceeding. Okay. At this time, our attorney will be swearing any witnesses that will be testifying today before the board. If you are willing, if you want to come up and present your case or testify, please stand up if you're capable. Raise your right hand.
Chair Camps, before we do the swearing in and members of the board, I do have a duty to inform you that pursuant to rules 4-1.7 and 4-1.10A of the rules regulating the Florida Bar, my firm and I have a conflict of interest with respect to agenda items 1 and 2, so I cannot provide advice to the board on those items, nor can any member of my firm represent the respondents in those cases. And so this does happen from time to time, and this is what happens when it occurs. It is my pleasure to introduce to you Mr. Dan Manzares. Mr. Manzares was previously the city attorney for the city of Clermont, and he will be sitting in for me as conflict counsel on items 1 and 2. He will also be swearing in any witnesses that will testify. Following a hearing on items 1 and 2, Mr. Manzares will leave and I can come back in and we'll be here for the remainder of the meeting. So with that, I'm going to give Mr. Manzares time to come up and I'm going to step out.
Good evening. Welcome.
Thank you, sir.
Yeah, are you want to do it? Are you ready to proceed, Madam Chairman? So again,
Yes,
as
sir.
the chairman pointed out, so again, as the chairman pointed out, if you were going to present any evidence to the board tonight, unless you are a licensed attorney who are not going to present evidence, then you need to stand right where you are. And as a notary of the state of Florida, I will swear you in. So again, if you're going to present at all to the Code Enforcement Board today, you need to stand right where you are, and we will swear in you in as a witness. You sure? And if you're responded and you're going to address the board, if you were responded and you're going to address the board today, you need to be sworn in. All right. Do you swear or affirm that the testimony you're about to provide in these matters shall be the truth and nothing but the truth? Just say I do. All right. Thank you, Madam Chairman.
Thank you. Okay.
Good evening. My name is Avery Dyan, and I'm the Assistant City Attorney. I'm just going to go over the agenda for tonight. We're going to start with item 1, case number 25000146, Encompass Health Rehabilitation Hospital. Just so you know, item 2 and item 1 arise from the same set of facts but affect different properties, so they are linked in that way. However, the respondent for item 2 is not here yet, so we are going to move item 2 to the end. After item 1, we will move to item 3, case number C23100021, Kevin Henshaw. And then we will move to item 5, which is case number C2506-00006, Helen Ross. And then we will move to item 6, which is case number C2507-0007, Grupo Cinco LLC. Then we will move to item 7, case number 25000044, Marlon Cojo de Carvalho and Sabrina Bastos de Oliveira Ferreira. I apologize for my pronunciation on that one. And then item 8, which is case number C25030021, Benjamin Anderson and Trudy Life Estate. And then if the respondents for items 2 and 4, we're going to, as they are not here at this moment, we're going to move them to the end. So then we'll move to item 2, case number 25000014, Seema Khanna, and item 4, case number C24120006, Colonial Tile and Paver LLC. Just a brief clarification. The respondent for item 2 has just arrived, so we will go 1 and then 2.
Good evening, Code Board members. Evie Wallace with the City of Clermont. And this will be case 25-000146, Encompass Health Rehab Hospital. Property address is 2901 State Road 50, and the owner shows up as also Encompass Health. These are city code violations 101-209, 101-2113, 213 for conditional use permit, and ordinance number 2020-30. This is from the property appraiser showing the location marked in red. That is the rehab hospital, Encompass Health. The case summary, the notice of violation was sent October 16th, 2025. Notice of violation for compliance date was October 24th, 2025, and it was a short time frame because the owner has been aware for several years now about the ordinance violation. It was also the management director, Maurice Lopez, received the notice of violation as well on October 24th, and he did speak to corporate. Also, the representative of the owner was contacted and contacted us. The notice of hearing was sent on October 24th, 2025, and it was delivered on October 31st, 2025. Status is non-compliant as of today. Just showing this slide that the notice of violation with how to comply for this property with the 2020-30 ordinance. The hearing notice that was sent. Hearing notice that was delivered. And in your packets, you should have received about 20 pages of the ordinance 2020-30, so I'm just going to the specific sections or the conditions that were not met. Section 1 provides a legal description. Section 2, the general conditions. Section 3, the land uses and specific conditions, which under number 1, the project will consist of 2 separate phases. This property is actually phase 1, approximately 12 acres with a 100-bed rehab center. The phase 2 would be the next case being presented. Again, the site map showing phase 1. And this hospital is in between Emerald Jana and Hancock Road. The phasing map in the bottom showing that location. This property is phase 1. Again, just showing that it's phase 1. That way it's a little bit more clear. And under the section 3, I marked number 7, where it says cross-access between both Phase 1 and Phase 2 will be required, as well as a cross-access to the development, which is to the parcel next to Phase 2 for the shops at Waterbrook. There's a picture that I took just showing the only entrance and exit is through the parking lot of Encompass Health, the hospital. A close-up still on the Phase 1 property, this property. This is taken August 11, 2025. Just showing the entrance and again, the only entrance and exit off of 50. And this picture is just showing, literally parked on the, toward the end of the Phase 1, showing a little bit of Phase 1 and showing further down Phase 2. Staff's recommendation to the Code Enforcement Board is to find the respondent in violation of the section stated, to assess a fine of $250 per day for every day the property remains in violation after December 17, 2025. If you have any questions regarding the ordinance, Kurt Henschel is also here to provide answers. You have any questions for me? And I know the representative is here of the property.
Can you help me understand exactly what the violation is?
Oh, sure. Go ahead.
Good evening, Kurt Henschel, Planning Development. Good evening, Kurt Henschel, Planning Development Services Director. The issue is the ordinance, as Evie just pointed out, there's approximately 100-foot stretch of access. What you're looking at here would be a driveway over to the neighboring property. That was a condition in the original ordinance that was not constructed yet. That's why we're here, because they haven't connected the roadway from one development to the other.
I see.
So they're required to put in that, just that length along the road and then put another entrance onto 50, is that what?
No other entrance, it's approximately 100-foot stretch of driveway, if you will. Connected, basically, so we're on the right portion, it would continue from that point due east, parallel to 50, approximately 100 feet.
And then just dead end in a field, or?
That's all the requirement was, yes. What that would do is it gets it to the neighboring property owner that was envisioned to be the cross access. That's how they're getting onto 50, is from the back. It's really in front of Encompass Health. That's their curb cut to come in. They have another access over off of the Waterbrook. No, keep going. Oh, I'm sorry. Yeah, that was it. You're right. So on the right-hand side, that essentially would be the access point. Right there on the right-hand side of that picture, you drive in, turn left, go down the 100-foot driveway, and then now you're on the neighboring property. That would be their access. They do not have a curb cut on Highway 50. Does that explain it?
Well, I'm just curious, like, this seems like a problem for that property owner, right?
It is for the neighboring property owner, yes.
Yes.
And that's why we're pursuing it. As for that.
Partially, and that's why we put it in the ordinance itself,
Okay.
to connect. Yes, you're absolutely right.
Is this isn't going to be used until the Phase 2 is developed, is that correct?
Well, either Phase 2 or that neighboring property develops. Phase
So it's a
2,
road to nowhere until
it would be,
the other property is developed?
correct.
Okay.
One other question. Is this road on the property that belongs to the owner, or is this road on the neighboring property?
Well, it goes to both. You remember this, when the ordinance for the Encompass Health came in, it was a very large piece of property. We wrote the ordinance for the overall property. Then it was apparently sold, a portion of it was sold off, and you'll hear that other portion on the next item, because all of it's under one ordinance, but there's two different owners.
Okay,
That's why you're gonna have one now and one next, yes, over the same issue.
okay.
Were there two different owners when the code, the ordinance was written?
There was one application.
Okay, so it is the original owner who failed to adjust whatever the original ordinance required of them to accommodate phase two.
That is one way to look at it. We had to notice both of them because they're both, now there's two owners now.
But
Yeah.
the ultimate responsibility falls on the original.
That's how we see it, yes.
Holder of the one who applied for the ordinance and the change or whatever you call
Correct.
it.
Can you make sure that we put your mics on?
Yeah, is it red?
One-
Oh, yeah, is it red?
Yeah, it's right.
Okay, just go a little
I'm
closer
sorry,
maybe.
I may be,
Yeah.
beg your pardon. Thank you.
Sure.
I have a question also. Is that parallel road in the easement of Highway 50?
No, it's all on private property.
Okay.
Okay. Is there anyone here who wishes to speak on behalf of this item? Have you been sworn in, sir?
Good morning, or good evening, Chair. I'm a licensed attorney. So, for the record, my name is Brent Spain, Theriac in Spain, 1809 Edgewater Drive, Orlando, Florida. And I'm here this evening on behalf of Encompass Health. And if Mr. Manzares would be so kind, there are courtesy copies of our PowerPoint presentation sitting right in front of you.
Oh, thank you.
Just Mr. Brackens didn't want to pass them out. And there's also one for you, Dan, and for the clerk. So again, my name's Brent Spain. I have the privilege of being here this evening on behalf of Encompass Health. I'm going to walk through the PowerPoint presentation with you all because I think this helps put it in context more so than the staff presentation. So the first slide is, that's the overall site on the top. That includes phase 1 and phase 2. If you look in the bottom image, aerial, you'll see the phase 1 and phase 2, the sections, and that's right out of ordinance 2020-30. So it was always envisioned to have a phase 1 and phase 2. And if you look at that aerial from the PUD ordinance, you'll actually see that 100-foot strip that the planning director referenced. That's actually in phase 2. It is not in phase 1. So phase 1 is owned by my client, Encompass Health. It's approximately 12 acres. And it has the rehabilitation hospital on it. The ordinance was originally approved in February of 2021. And the hospital was completed and open in April of 2023. This is a larger aerial. This is the same aerial that was actually in the staff presentation. That's the property appraiser's designation of our client's property. You can see it outlined in red. And then actually, if you look up right south of Highway 50 there, you'll see the number 100. That's actually the measurement of the strip of property that's in question. So that's what the violation has to do with, is there being no access road across that 100-foot strip, which again is outside of the phase 1 property, is not on my client's property. And here is the notice of alleged violation that we received. The staff included part of this in their packet. But again, the alleged violation is that we must comply with the CUP and provide access to neighboring property for access to and from State Road 50 per ordinance. And then, and this is the line highlighted in yellow, it says vacant piece of parcel circled in blue on other document is area needed for access to State Road 50. And you'll see that's the city staff's aerial there with the blue circle, which actually the blue circle is right at our client's entry off of State Road 50. And as I walk through here, you'll see that we've actually provided cross access on that driveway area. As the chair indicated, the burden of proof is on staff in this case. So I want to walk through a couple key provisions of the PUD ordinance. I know it's being referred this evening as a CUP, but my understanding is it was approved as a PUD. One of the key provisions that wasn't mentioned during the staff presentation is paragraph 2. It's section 2, condition 2. It's highlighted on the left side of the screen, and it reads, "The property shall be developed in substantial accordance with Exhibit A hyphen conceptual site plan SP-1 prepared by Kimley Horn. Formal construction plans incorporating all conditions stated in this permit shall be submitted for review and approved by the Site Review Committee prior to the issuance of a zoning clearance or other development permits." And then on the right side of the slide, that's the condition 7, which they're alleging that we are in violation with. And I want to just emphasize a couple things. When you read condition 7, nowhere in there does it say a road needs to be constructed. In fact, nowhere in paragraph 7 does it use the word construct, install, built. And those terms are used in other portions of the PUD ordinance, but they are not used in paragraph 7. What paragraph 7 says is cross-access between phase 1 and 2 will be required, as well as cross-access to the development to the west and east. And then it goes on. So what was submitted to the city and approved with this PUD? This is a blow-up of the conceptual site plan that was attached as Exhibit A to the approved PUD ordinance. And you'll see I've circled in red the access area. And again, Section 2, Condition 2 of the PUD ordinance says, quote, "The property shall be developed in substantial accordance with Exhibit A, conceptual site plan SP-1 prepared by Kimley Horn." That is the site plan that was attached to the PUD ordinance. And you can see circled in red, there is no road going across the 100-foot strip. That is, again, not on my client's property. It is on phase 2. But if we go to the next step, you'll remember the Section 2, Condition 2 that I referenced said, and it's at the bottom of this slide, "Formal construction plans incorporating all conditions stated in this permit shall be submitted for review and approved by the Site Review Committee prior to the issuance of a zoning clearance or other development permits." This is the cover sheet to the approved construction plans for this project. And on the right-hand side of the slide, I have a cropped blow-up with circled in red. You'll see they were approved, site review, Clermont, 10/8/2021. So these are the reviewed and approved construction plans for my client's phase 1 development. If we go to the aerial site plan, you will see on the slide overhead circled in red that between the site plan, conceptual site plan, and the approved construction plans, my client was required to do that turnout, the stub out to the phase 2 property. And that's circled in red on the overhead. So that was the change between the conceptual plan and the approved construction plans, was to build just a stub out and provide cross access to my client's property line. If you go to the overall site plan, again, this is the city-approved construction plans. You'll see, again, on the overhead is the stub out for the cross-access that ends at my client's property line. And then circled in red, in the yellow on this approved site plan, it says future cross-access connection. So the approved site plan did not envision my client building any road across the phase 2 property to the property further to the east. And then again, this is the pavement marking and site plan, page C-07B of the approved construction plans. And again, you can see that the pavement ends at my client's property line. And in fact, the approved construction plans even have a call out for my client to install reflective markers at the end of that stub out. So we would submit, if our client was obligated under their approved construction plans to build a road across property it doesn't own, it would have been reflected in the approved construction plans, including the pavement marking. Staff would not have approved something that has reflector markers designating the end of the roadway. And again, these are the current site conditions. This is a current aerial. As you can see, my client has built it in strict accordance with the approved construction plans. We added the stub out and the turn to the Phase 2 property, and it ends at our client's property line, just as denoted in the approved construction plans. Similar to the staff's pictures, these are current conditions. I took these pictures last weekend when coming through Clermont. So again, you can see it comes in off Highway 50. It turns toward our client's property and then also turns the other direction and ends at our client's property line, just as called for in the city-approved construction plans. So what has my client done to further comply with the PUD ordinance? We have granted cross-access to the Phase 2 owner. On the screen on the left, that's the first page of the recorded easement and use restriction agreement that provides cross-access to the Phase 2 property owner. And on the right on the slide, you'll see Exhibit A to that recorded cross-access easement agreement. And I've circled in red, you'll see the area circled in red. There's a box, and it's called out as access easement. That is the area where our client has built that turnout and stub out to the Phase 2 property. And then there was a temporary construction easement granted for connecting to that area under that easement agreement. Our client has also offered that exact same similar access, cross-access easement agreement to the property, what on the screen will be referred to as the up property, which is further to the east. Again, you can see the first page on the left of the proposed cross-access easement agreement, and on the right, you can see Exhibit A to that proposed cross-access easement. Again, granting the up property cross-access across our client's driveway entrance on the State Road 50, which is in the hash mark on the right-hand side. But again, you'll see that the Phase 2 property is in between our client's property and the up property. And then with respect to the Phase 2 owner, because there was mention that the Phase 2 was sold, and that is correct. And on the slide, this on the left, that's the first page of the special warranty deed from September of 2022, selling Phase 2 to the current Phase 2 owner. And on the right-hand slide are the permitted, right-hand side of the slide are the permitted exceptions to that sale. And you'll see that permitted exception 9 says, and I'm quoting, "The terms, provisions, and conditions contained in that certain City of Clermont ordinance number 2020-30, recorded in book 5685, page 1322 of official records." So the Phase 2 owner bought the property subject to and conditioned upon any conditions that were in the PUD ordinance, including any requirement to provide cross-access. Our client doesn't own that 100-foot strip of property. Our client doesn't have the right to grant an access easement across property it doesn't own. We don't have the right to build across property we don't own. So the suggestion that somehow we're violating the PUD ordinance by not building across property we don't own and not granting an easement across property we don't own, we would submit as flawed, because legally we can't do that. We have no right to do that. That item is number 2 on your agenda with the Phase 2 property owner, who's also been cited with the same alleged violation that our client's been cited. But again, we've done everything that's been required of us under the PUD ordinance. You saw the approved conceptual plan. You saw the revision that was made that required the stub out to the Phase 2 property line. And you've seen the aerials that demonstrate that we built it in strict accordance with those approved construction plans. If the city had wanted us or demanded a road be built all the way across Phase 2 at that time, I suppose they could have asked us, you need to revise your construction plans. We're rejecting those. That was not done, and it has not been suggested that we have not built in accordance with those approved plans. And we've granted the cross-access easement already to Phase 2 owner, and we've already indicated both to the city and to the up property owner that we'll extend that same cross-access across our client's property so they can get to Highway 50. But we have no legal right to grant easements across someone else's private property. So we would ask you to find our client not in violation based on the PowerPoint and the evidence included in the PowerPoint. I'm happy to answer any questions, and with me this evening is Brian Wall from Encompass Health as well.
May I ask a question, Madam Chairman? You represent Encompass, sir, is that right?
Yes, sir.
And Encompass originally owned all of this property?
That's correct, sir, yes.
And Encompass got the general use or the conditional use permit? They were the applicant, they were the ones who obtained the conditional use permit for this property?
They owned the property when it was issued, yes.
Well, you applied for it or somebody else applied for it?
I believe Encompass applied for it, but I
Okay.
haven't looked at that because the issue
Well, no,
here.
I'm not clear on this, and that's why I'm
Yeah.
asking you. So the property was granted a conditional use permit with these requirements. Did Encompass anticipate selling this property when it obtained this conditional use permit?
Well, if we go back to the slide. The bottom is the phasing that's included in the approved PUD ordinance. So it was always envisioned that there would be a Phase 1 and a Phase 2. Phase 1 in the PUD ordinance is the 100-bed rehabilitation facility, which is what Encompass does. Phase 2 in the PUD ordinance is for general commercial uses, which Encompass does not do. So it was always envisioned that Phase 2 would be sold off to a commercial developer because that's not what Encompass is in the business of doing. And again, so when you follow that through, as you can see, the demarcation on that aerial for Phase 1 and Phase 2 from the beginning has always been there. So it's not like my client sold the property and then when they sold it, chopped out 100 feet of the property. It has always been a separation. And again, when you go to the approved conceptual plan on the PUD ordinance, again, it's got Phase 1 and Phase 2, and you can see the remaining property, C2 general commercial zoning, is right there on the approved conceptual plan, which is not what Encompass builds. And then again, the approved construction plans modified that entrance to do exactly what our client has done, and that is build that cross-access to the extent of their property that they own.
I'm a little bit confused with the geography here, but maybe if you can show this slide so everybody knows what we're talking about. That one is good. That, like arm that extends behind the property to, it ends up, I guess, what is gonna be a street someday?
Are you talking about on the bottom?
Yeah.
On the south?
Yeah,
Yeah, I believe that's gonna end up there extending a roadway east-west. Yes, yes, sir.
so you are saying that that part of the Phase 2, that is really on Phase 2 property, that you sold that planned or intended roadway to Phase 2?
I'm not sure what you're referring to on the screen, so if you can point to it.
So this is your property up here, Encompass Health.
Yes, sir.
I'm calling this is a planned roadway, or access road, whatever you would call it.
That's our client's property.
And then ultimately, this is gonna be Hook Street. So you're saying, so you're saying that access road, which would give you access to Hook Street from your property, is really now Phase Two's responsibility because you sold them the property. Yet you're as big a benefiter of that road as Phase Two would be.
No, the violation this evening doesn't entail the right-of-way for Hook Street. In fact, we're in discussions right now with Lake County to dedicate right-of-way for that Hook Street extension. What we're here about this evening is up on the north end of the property, just south of Highway 50, where our client's property line ends in red, and then there is a distance of 100 feet between that Phase 1, Phase 2 property line and the property line further to the east. And it's always been laid out that way. My client has no right to build over somebody else's private property. We can't grant easements across other people's property. And the fact that the property was sold is not directly relevant either, because one, the conditions of the PUD would run with the land. But one step further, as I showed, the deed for the Phase 2 property expressly lists the conditions of Ordinance 2020-30 that the property is subject to this. So the Phase 2 property owner bought the property subject to any conditions in the PUD ordinance.
So I just want to be clear. This originally was owned by one party, all this property. They submitted an application to build the structure and to build roads. They then subdivided the property and sold property that they divided to someone else. Is that not correct?
Somewhat correct. Somewhat correct. It's not subdivided
Somewhat?
because it's not platted as a commercial parcel. But again, none of the phasing lines were changed between the PUD approval, what is on the screen, and what's there today. Our client didn't sell property that differs from what the city approved plan showed. And I would disagree that anything in paragraph 7 requires my client to build any road. It says cross-access between Phase 1 and 2 will be required, which we're not disputing. We've already have a recorded easement providing cross-access between Phases 1 and 2, which we showed on the screen. And we've already indicated and we've shared a cross-access easement with the city and the property owner further to the east, saying we're willing to give the exact same easement, cross-access across our portion in red up there that exits out on the State Road 50.
I understand that. I just want to be clear that what's being asked is that you're to build a road which is not on your property.
That is what they're saying. That is what they're saying, that we're responsible and we're in violation to do.
That's what I'm trying to get down to.
Yes.
The bottom line is this: an application was sent to the city to do construction work. The property, after that application was sent in, the property was then, partial of that property was sold to someone else. Am I understanding that correctly, or it's not sold? Because you're saying that it's not your property, right?
No, the Phase 2 property has been sold. That's
Okay,
not in
so
dispute.
we're talking about two separate pieces of property.
Yes,
But
ma'am.
originally, it was all one, and the application was submitted as one piece of property, which is no longer the case.
Well, it was submitted as one site with two delineated phases, which it's always been a Phase 1 delineated and a Phase 2
I
delineated.
know you're using the terminology phase, but I'm thinking more of the terminology of, like anyone else knows. He has his property, there's a survey that shows a property line which he's responsible to take care of. I'm responsible to take care of my property, so on and so forth. I understand that, and I get it. What I'm trying to clear up here is that this originally was considered one piece of property. It is no longer considered one piece of property, because either it is or it isn't. You can't be in the middle.
It's legally two pieces of property now with
That's what I'm
separate
getting
parcel
at.
ID numbers.
Yes,
And
that's
they're
what I'm getting
depicted
at.
on the screen right there. Ours is in the red, you'll see it right on top of the building, and Phase 2 is in the middle of their piece of property in the woods.
Okay.
May I ask another question?
Certainly.
So the portion under contest here is adjacent to Hancock Road? Or is it
No.
that spindle behind the Advent Health?
Let me see if I, you all know, does this have a pointer on it? No.
Yeah, I see
Okay,
it.
yeah, yeah. All right, so this will help. This area right here,
Yeah. You
that
had a
is,
red
well,
circle on around it before.
it's this area that looks like
Okay.
it's dirt, which as you
Okay.
can see is outside our client's property. We've built the roadway
And the stuff.
right to that red line and then stopped.
I'm sorry, I was confused earlier. I was using the other
Okay, yeah,
roadway or whatever it's gonna be called. So Encompass purchased some property, phased it into phase one and phase two. Under the conditional use permit, you were obligated to complete that excess that's under dispute right now, saying that it's phase two's responsibility. But when the property was originally granted the conditional use, Encompass agreed to complete the requirements, including this access road. You then sold the property to another person and did not include the fact to them that they had to complete this road extension. So in effect, it's more of a contractual dispute between you and the phase two owner. The phase two owner was unaware of this, which you were or should have been. So in effect, somebody is in violation. And the one that first created this property conditional use permit was Encompass. So it seems to me Encompass is the most liable in terms of the city's requirements. And that the phase two owner may have to compensate you under your interpretation. But the city is looking at you to comply with the conditional use permit.
well, if I could address some of that. One, if you took that logic to a logical extreme, anytime somebody comes in and is not a vertical developer, but they get entitlements on the property, you would be saying that that person who got the entitlements on the property remains liable from that point all the way to the end, even though they're not doing any of the vertical construction. And again, we keep saying that the CUP ordinance, which again, my understanding is the PUD, nothing in condition 7 uses the word build, construct, install. There's not the word road in paragraph 7 at all. Nothing in there says that Encompass shall build a road 100 feet long across the phase 2 property. And the city knew how to use those words because there are in other sections in that PUD ordinance. They've told the applicant and developer when they have to install something and when they need to construct something. And then my client didn't, I would say, mislead anybody about anything or take this obligation. Again, on the overhead, this is the conceptual plan that's on the approved PUD ordinance. Nowhere on there is there a access road across the phase 2 property line. In fact, there's not even a turnout or a stub out on this. When our client went through the approval process with city staff, and this is important, when you look at the slide, the overhead slide right there, this is the language right out of the approved PUD ordinance. It says formal construction plans incorporating all conditions stated in this permit shall be submitted for review and approval by the site review committee. Our client submitted plans and the city staff reviewed these and approved it with the turn and stub out to our client's property line. So presumably, when staff reviewed this plan, they concluded that this plan incorporates all conditions from the PUD ordinance to the extent that our client can build only on its property. And in fact, the site plan, which is on the overhead, right now, calls out that there will be a future cross-access connection at that point. So my client is recognizing, look, there's going to be cross-access connecting here onto our property, and we're going to grant cross-access. But again, it's a misnomer that paragraph 7 of the PUD ordinance imposes any requirement to construct an actual road on anybody else's property. It's nowhere in paragraph 7 if you read it. And we've done the access to our property line, we've granted cross-access to phase 2, and we've offered to cross-access to the property further to the east.
How would they have known to include that if it was all one property and one owner at the time? See, that's the problem.
But
You
how they
owned the
would-
property at the time that paragraph was written.
But how they would know is when they reviewed the construction plans that are on the overhead, they didn't impose that as a requirement. What it is that your driveway is going to end at your phase 1 property line, and then there's going to be a future cross connection here. I've been involved in lots of developments. I've never had any type of city impose a requirement that you're going to build a road that solely benefits another developer outside of the PUD. We've done what we can by building to our property line. We built in accordance with the approved construction plans. The city's now coming back and saying, we want you to do something different than what was on your city-approved construction plans. Even though the PUD ordinance says you have to build in accordance with your approved construction plans, which is what we've done. So if anybody has responsibility for granting a cross-access across that 100-foot strip, it would end up being the phase 2 property owner, which again, this wasn't something where the ball was hidden. Again, here's the special warranty deed selling the property to the phase 2 owner. Long before the hospital was open and complete, and highlighted in yellow is the condition that they're buying it subject to the terms and conditions of the PUD ordinance. Any sophisticated buyer does due diligence and would say, I'm going to look at that copy of the ordinance. It's referenced by book and page number, and their lawyer advises them as to the requirements. And they were aware of cross-access being a requirement because our client offered it to them, and it's recorded, it's on the screen, and it makes reference to that this is being done pursuant to ordinance 2020-30. So our client's done everything that we believe we're legally obligated to do.
So in layman's language, you gave phase 2 owners notice that they would have to complete this access road.
That they would have to
To
provide
comply with
cross-access, yes.
with the conditional use that required the access road.
They would have to comply with the conditions in the ordinance, which include this condition 7, yes, absolutely. It's in writing.
Just to clarify, can we ask council, if a property that is under a PUD transfers ownership, is the original owner under any obligation for that transferred piece of property, or is it the new owner's responsibility?
Well, I think what's confusing everybody here is that, or maybe it makes it a little bit more confusing, is we're talking about a PUD that applies to about 32 acres. Right? It doesn't just apply to phase 1, it doesn't just apply to phase 2, it applies to all of the property that's there. So because the way the city has presented this case is essentially a failure to comply with the PUD, all property that's part of that PUD is subject to that violation, because there's one PUD for the entire parcel. If this was 2 separate PUDs, one for phase 1, one for phase 2, then you could follow along with Mr. Spain's argument. I don't necessarily disagree with what he's saying, right? However, I think this issue needs to be looked at from the fact that it's one parcel. It was developed as one parcel under one PUD for a total of 32 acres, and this condition doesn't specify anything different between phase 1 and phase 2. It says there'll be cross-access from phase 1 to phase 2 and all to the east and to the east. So it doesn't clearly put the onus on either phase 1 or phase 2. It just applies it to the whole parcel. So to answer your question, in this case, I think that condition in the PUD could be held against the phase 1 property owner because it applies to the entire parcel, right, the way we are currently today. And I hope that makes sense.
Well, I'm just wondering, is that, so if there's a violation that's strictly on the Phase 2 property, it could still be a violation for the
It's, it
Phase
could,
1 property?
the way that the city is presented this case, and the city can correct me if I'm wrong on this, is that this is a failure to comply with an existing, with the PUD. It's a condition in the PUD. And so your job would be to interpret that condition as the city has presented it and determine whether this condition has been complied with. And if it has not been complied with, then unfortunately for the parties, because of how the PUD is created, it probably the only way you could move forward with it is to basically find both property owners in violation, and basically see if they can figure out how to resolve it. Again,
What's the remedy for the first property owner if it's on the second property owner?
well,
Like, what can they
that's,
do?
and I was gonna ask Mr. Spain this question, because he mentioned in the tail, if I could, Mr. Spain. I think you said you offered to give cross access to the easement. Did I hear that correctly?
This is, and we shared this with the city previously, that's a proposed access easement to the up developer that's further to the east, and you'll see on the right is the Exhibit A that is hash marking our client's private property, saying access easement area,
So
and
did
the
that,
access road.
was your offer to go all the way to the boundary line to what's referred to as the UP property?
No, because we can't, as you can see, the Phase 2 property is outlined up there. We have no rights to grant easements
Okay.
over other people's private property. And I would,
Hang on a
again,
second,
yeah.
thank you. So, assuming, or just try to, assuming that you interpret the way, if you interpret Section 7 to basically, let's look at it from the more in lines of what Mr. Spain said. If you interpret that condition 7 that we're talking about to me, they don't have to build a road, however, there has to be a cross-access easement, right? Then the way the condition gets complied with, I believe, is that crosshatch piece there that Mr. Spain is referring to, that offers, and then the owner of Phase 2 provides a similar cross-access easement for the gap piece between Phase 1 property owner and the boundary line for the UP property, right? Because Mr. Spain has said, we're willing to give our piece, but we can't give the piece that on the little gap piece there. Correct with that?
exactly, and we have the pavement in that
So-
area. So
so
we've
if
built
you-
the pavement to our property
So
line.
then the next interpretation you'd have to look at is whether that condition requires them to build a road, in simple form.
Okay, so you don't have the easement, they don't have the easement to get across there right now, is what you're saying. You're willing to give them
Oh,
the.
we've offered it to them, we've provided that to the draft to the city previously.
Okay, but it
Yes,
doesn't-
and that's all we can do is grant an access easement on our property. So,
Does,
At this point, they could, well, they could have granted it when they sold the property, before they sold the property, but, I think you sold it back in 2022, and this thing started coming up after that, so. So as much as I know we're trying to move through these individuals, I think it's probably important to maybe move on to the second case and hear from the other
Yes.
property owner, because they play a role in reaching the compliance. Either way, look, again, if you believe that they're supposed to construct a road, right, the Phase 2 property owner is still gonna have to do something. If you believe all it is a cross-access easement, then the Phase 2 property owner is still gonna have to do something.
what is staff proposing? Are you proposing that they need to build the road, or you think that the easement is sufficient to meet the requirements?
So the issue is access, and it is the city's contention that cross-access means a road.
I'd like to make a motion. Based on the testimony and evidence presented in case CEB 25-000146. I move to find the respondent, Encompass Health, is not in violation of the City of Clermont's Code of Ordinance as listed in the notice of violation filed on this matter. I move to find the case CEB number 25-00146 be dismissed.
Do I have a second?
I'll second.
All in
Aye.
favor?
Aye.
Anyone opposed?
Nay.
that
Oh, sorry, aye. Oh, sorry, aye. Aye. Yes.
Aye. Yes.
Thank you. Thank you.
Okay, and this is item number two, case 25-000014. It's a vacant lot next to Encompass Health. Owner is Seema Khanna. These are the city code violations, again, 101-209, 101-213, under the CUP and ordinance number 2020-30. And this is the vacant lot, property located next to Encompass in red. Case summary, the notice of violation was sent August 11, 2025, with a compliance date of August 27th, 2025. Notice of violation was delivered on August 18th, 2025, and the hearing notice sent was September 11th, 2025, and delivered September 13th, 2025. Compliance status as of today, non-compliant. And these are just the notices with it being showing that it's delivered. Hearing notice showing that it was delivered. Both the owner and the attorney have been in contact with myself and Kurt Henschel since August of 2025 by phone and email. Again, showing the 2020-30 ordinance, providing the legal description in section 1, the general conditions in section 2, and the land uses and specific conditions under section 3. Noting that number 1, the project will consist of 2 separate phases. This will be phase 2, approximately 20 acres. C2, general commercial use. This is the phasing map showing phase 2, where the vacant property is located. The section 3, number 7, referring to the cross-access between phase 1 and phase 2 will be required, as well as cross-access to the development to the west and east, the shops at Waterbrook. The pictures again showing the only entry and exit through phase 1 to get to phase 2. And that wooded area is part of phase 2. And again, that's part phase 1 to phase 2 going eastbound to show where the future development would be. And this was taken October 20, 2025. Staff's recommendation to the Code Enforcement Board is to find the respondent in violation of the section stated, to assess a fine of $250 per day for every day the property remains in violation after December 17, 2025. And I believe the representative and the owners are here. They have not been sworn in, but they do want to testify. If you have any questions for me prior?
Could you swear them in, please?
Yes, we will when he gets to the podium.
Good evening. How are you? My name is Craig Eskenazi. I am a licensed attorney in the state of Florida.
All right, thank you.
My address is 410 Gulf Atlantic Highway, Wildwood, Florida, 34765. I'm here on behalf of the Khannas. They're here today. I think you guys heard most of what happened in the last case, and the gentleman was so kind to put up his PowerPoint presentation. I just want to focus on a couple of things for you. When the conditional use permit was first applied for, that was applied for by Encompass Health. Now, Encompass Health, for years, benefited from that conditional use permit. And by doing so, what the city attorney kindly said was that this was one piece of land when that PUD was done. And so by virtue of being one piece of land, they benefited from that conditional use permit. Today they come in and say that we don't have to do anything, and it's because we sold the property and it's considered a phase 2 development, we don't have anything to do with it anymore. But we benefited from the city in our application. That's essentially what they came up and said. Our argument is that we want to work with the city and grant an easement with the other party. However, it's up to the party to build that road. That's number one. And because they benefited in time from getting the permit, and it is considered one property, and it's one PUD, by the way, as the city attorney pointed out, that they're still under that obligation to build that road at this time. So I would take any questions from you, because I think that you guys went through this.
I have a question. So, based on everything that I saw, the blueprints, everything that were signed off on, it's my understanding and what everything that I saw, that they fulfilled what they had requested. They provided the access, the easement that moves through your property, and phase 2 is that 100-foot section of property that's in question that was listed from the beginning, correct?
Somewhat correct, yes.
Okay, so what I didn't see anywhere was anyone specifying that there had to be a road through
I
there.
think-
So do you bring something that shows that they actually, I don't know, in sense sold it to you without fulfilling what they were supposed to?
Well, there's nothing, as the attorney pointed out, that says in section 7 that there needs to be anything built, by the way, right? So what they did was basically apply for a permit, right? A conditional use permit, and then sell their obligation away, which we argue that they can't do. So, but there's nothing in section 7 that says that anything has to be built. But if it does, they would be the ones who have to build it.
I have a question. This Phase 2 property, what is the timeline for this property to be built?
In any of the documents that you saw today, and in any of, there's no timeline that is specified, not in the warranty deed, not in any of the documents that say there is a timeline. You're dealing with people who intend to develop the land at some point when the money is available to develop that land. So there could be a timeline. It just depends, but I would expect it within, say, 1 year to 2. I mean, there is a timeline to get this done. Trying to work with the other party and landowner to do this. But again, they came up and said that they offered the city, I think he put up a drawing, they offered the city to do a cross easement or something that was up there. We never received that, nor do we ever have any communication with the other side. I can tell you that.
So I guess my next question would be, maybe this is probably for the city. The third parcel over that we're calling the up property. So is this person needing access or easement? Is that part of why we're here? Or, because I think it goes with Madam Chair, what she's saying is if it's a non-issue right now, what's, right?
Yes, I'm trying to understand.
I believe there's a representative from that property in the audience here. I'm not sure. Lee, if you want to comment, but I'm told from them, yes, they do need access across this piece to get to theirs, because they do not have access directly from Highway 50.
Okay.
This is their access.
May I ask a question, Madam Chair? Sir, the previous attorney represented in one of his PowerPoints as one of the terms of the sale to your client, the terms, provisions, and conditions contained in the in that certain City of Clermont ordinance number, I'm not sure it's 20, if it's 2020-30, recorded in book, I'm not sure of the number, but I
So
think they,
you're referring to the deed?
this is the Phase 2 owner where you apparently signed an agreement with Encompass when you purchased this land. And their position is that Encompass sold you this property and gave you that obligation. In other words, you contracted the obligation. In other words, it wasn't yours, but in purchasing this property, you agreed
That's
that
our argu- that was
it's
his
on
argument.
us.
Yes, that was his argument, sir.
Okay, how do you argue this clause? I mean, he's saying this clause says that to you.
Yeah, but I would, the only way I would kind of argue that is one piece of property. See, there is one PUD in this case, there's not two. So if there was two separate properties, there would be two separate PUDs. And that's what I would tell you.
Okay, no, I mean, I understand it's all one big pot.
Yes,
But so was the property.
correct,
And then they said it was Phase 1 and Phase 2.
correct,
You're Phase 2.
correct,
You come in, we want the property, it's a good piece of ground, we're gonna make money.
correct.
And you sign a contract to buy the property. And they slipped one by you, it seems, saying, this PUD requires this road to be extended, and nobody objected to it. Because I
Sir,
see your
can you
side
go-
of the
Can you go
argument.
over there to that podium, please? I know.
You swear yourself in.
Sir, finish what your thought. Will you finish with your
Oh,
thought?
I'm not disputing your contention, but the rebuttal to that was, and apparently accepted by this board, that they by contract, obligated someone else, and that someone else is your client.
Yeah, go ahead. You have to swear
Well,
yourself.
can you, sir, you raise your
Hi,
right
my
hand,
name is
please?
Rohan Khanna. Hi, my name is Rohan Khanna. I'm an attorney in the state of Florida.
You are?
I'm an attorney, yes, sir.
You're an attorney?
I'm an attorney, yes, sir.
Okay, all right.
Litigator, but
Put your
yes,
hand down.
not much of a litigator, but yes, I'm a transactional attorney. So new to me to speak in front of people. But I think that we're delineating between a Phase 1 and Phase 2, and that, like the city attorney said, that's not really accurate and/or fair. The PUD was approved for a piece of property, and the obligation was on the original applicant of the PUD. Now, I haven't seen a situation where you can sell off public liability via private agreement. Maybe they have a contractual right, if there was an obligation in the contract to give a cross-access easement, but the obligation would still be on the original applicant. And I want to clear that we have no issue giving an access. We're happy to give a cross-easement access and do what we need to do. I think the contention would be that we don't have an obligation to build a road if there was an obligation to build a road. I think Encompass benefited from the application, benefited from the PUD, benefited from the sale of the land, and I think it would be unfair now to require the new owner of the land to now do a liability that was on the original applicant.
And you're the owner of the land, correct?
I'm the son of the owner of the land.
So,
Yeah, I'm just an attorney. I don't do this kind of work, but I'm just here to help out my mother.
there should have been some due diligence, like in the middle of this.
And there was due
in
diligence,
this
sir. There was
process.
no obligation to build a road at any time. We never saw that. That wasn't brought to our attention. We agreed to dedicate a few acres to the city of Clermont, but there was no obligation to build a road.
The city of Clermont says that you guys were obligated to build a road, that someone was obligated to
I think the
build a road.
previous applicant's attorney made an argument that there wasn't, and I think the panel agreed with that there was no obligation to build a road in any documents.
But someone, if the matter here is giving access to the third parcel of land because they're locked, then someone is responsible, and the first attorney presented, everything that was stamped off by the city of Clermont that was approved.
Regardless, the ordinance required them to give access. I mean, maybe if the documents were incorrectly approved, they're still obligated to do what the PUD states. and give access and build the road if there's an obligation to build a road.
I have a question for the city.
For the city?
Yes.
It may depend on the question, so.
Yeah, the question is this. Now, I think these parties are very concerned about is construction and constructing a road, putting down pavement, curbs, water, drainage, all that stuff that goes with building a road. I also know that we have a lot of roads here in Florida, including in the town of Clermont, that are not paved, they're dirt roads. So since, to the best of my understanding the access, and there's nothing stating that it has to be a concrete or blacktop road, would the city be satisfied with a road if they take a bulldozer and just cut a road like they do in a lot of places, because you gotta cut a road first? Would that be sufficient to satisfy?
No, it was always our intention that it would be a driveway, an accessible driveway for vehicular traffic. And that wouldn't be our intent to have just a plowed bulldozed road.
No, 'cause I'm just asking,
Yeah,
'cause we do have a lot of dirt roads here that
we
people
do,
travel
right.
down.
But our intent, we have this in other conditional use permits, other PUDs that cross access. That's always intended that it's a road. And also, I just want to point out that the neighboring property owner, to answer some questions, is standing back here too, if you'd like to hear their point.
Okay, thank you.
That was the intent, then why wasn't that in the original construction plans approved for the original owner when they built on that property? And if that was the intent, that was the intent for them. If they wanted to sell that intent, they should have corrected that. But the obligation is still theirs. They were the ones that applied for the PUD. They received the benefit from the city. The city had an intent, and they didn't fulfill that intent. How can they sell a piece of property and now be relieved of their liability? I'm having a hard time understanding that. Again, we're happy to do what we need to do, but I don't think that my client should be required to now build a road after they purchased this piece of property with an intent to dedicate acres to the city of Clermont. So they already paid a substantial sum, and they're not a big-time developer. They're properties owned individually. It's not owned by a large company.
Well, they would have to build some type of pavement road in there to get.
Ma'am, if you want to speak, you have to come to the podium.
But ma'am, I think the obligation was on Encompass. Now, because they didn't want to do this, they sell the property, and now it's someone else's problem. They applied for the PUD. Maybe the construction documents were stamped incorrectly by the city. That does happen, but the obligation was still on the original owner.
And Madam Chairman, I'll go back to what I said in the earlier case. The PUD encompasses the entire 32 acres. Whoever owns that 32 acres now until the end of time, for as long as that PUD is in place, has to meet the conditions of those PUDs. So there may be a contractual issue between the Phase 1 owners and the Phase 2 owners, but the way the case has been presented, it's failure to comply with one PUD. Everybody that owns dirt in that PUD has to comply with the conditions of those PUDs. And so the way the law works on that, it doesn't recognize one obligation over the other unless it specifically says that in the PUD, and it does not specifically say that in the PUD.
Yeah, and just to piggyback on what the city attorney's saying, I think the violation itself, right, that has been given to Mrs. Khanna is void. That violation is incorrect. It's not a correct violation. It's not in compliance because of what the city attorney is saying. You cannot have it both ways. If you dismiss the case from the previous owner, Encompass Health, you have to then therefore dismiss the case against Mrs. Khanna because it's the same piece of property. That's the original thing I'm saying. It may not be a good thing to do, may not be a bad thing to do, but if you're going to do one, then you have to do the other because you're dealing with the same piece of property. Not one, you're not dealing with two separate PUDs. That's the issue here. So perhaps there's a private way to deal with this between the parties, but it's not for the city to say you're in violation of an ordinance that's defective. The ordinance itself, not the ordinance, the violation of itself is defective based on what the city attorney is telling you. And therefore, the case should be dismissed. If you dismiss against one, you need to dismiss against the other. There's a better way to deal with this than being in violation of this.
Just so we're clear, I'm not the city attorney, I represent the board.
I'm sorry. It says the city attorney. That's what it says, just for you.
May I hear from the other gentleman, please?
Good evening.
Have
My
you
name
been
is Lee Brewster, and I am a licensed attorney in the state of Florida. My bar number is 107828, and my address is 16620 Lake Trail Drive, Clermont, Florida. I'd be happy to answer any questions you have in regards to UP Development, who is the landowner directly to east of this. I've had personal experience for several years, so hopefully I can provide some illumination on what's happened.
Please elaborate.
Well, if no specific questions, I can take you back in time a little bit. We were in negotiation with Encompass in 2022 regarding that access point. In October of 2022, we discovered that two competing permits for access have been issued by the city of Clermont, and FDOT said they could not approve both of them. We agreed to work it out amongst ourselves, but by January of 23, we found that Encompass had gotten approval by FDOT to build the access point they want. The problem for us, as we've explained to the city a number of times, is we have a tenant on one of our lots, Aldi. They require truck access. The Encompass access point will probably cause us to go into litigation with Aldi because we cannot provide the access that's required under the lease we wrote. We've been in touch with the city about this all along. We were in touch with Encompass in early 23. They made it very clear to us that the only thing they cared about was opening on time. They did whatever they had to do to get the access point they wanted and they needed, and their only concern was their opening date. We actually put the Phase 2 owners, we had that under contract at one point, after they bought it from the previous owner, who we also know. So we knew all along that Encompass intended to sell this property, had no intention to develop it. We eventually fell out of contract with them, and they sold it to the current owners. We've talked to the city numerous times because we need a road to connect to. We still think that Encompass should be forced to build the access point that we'd agreed would be built, that then they failed to honor. But in any case, to allow both landowners not to build a road so that we don't have fire, health, safety access to our property is unconscionable. There has to be a road we can connect to. We have approved permits for our horizontal construction on the commercial portion. I have 2 tenants who are prepared to build. I have multiple other tenants who want to come in on the other lots, and we're in for permitting on our residential portion to the south. UP Development has paid a lot of tax money to the city of Clermont and to Lake County. They built the previous Hobby Lobby and Dick's Sporting Goods that's now relocated. They're still the landowner or the landlord of the previous Dick's location, and they have been here in Clermont since 2017 as the owner of that property. It is very disheartening to see the board relieve Encompass of their responsibility to build that road when they've already escaped their responsibility to build the access point. That was the access point that we applied for, had approved, then agreed to work with them when they went behind us to get the access point they wanted. And now they're getting to escape their responsibility to build this road the way they want. Any other questions?
How are you gonna deal with the truck issue since that entrance really doesn't look like a
I don't know.
truck entrance?
I've got the engineers looking at it because there's a minimum turn distance. And the way it was designed, they would make one right turn off at 50, then one left turn into the loading dock. The way the Encompass has set it up, now it's a right, then a left, then a right, then a left. Also interesting is that when Encompass built their property, where it terminates, when they say they're granting access, that's not true. They put up blockades I had to send a picture of those blockades to the city to force them to take those blockades down so we would have access to our land. They also built it at an elevation that's going to make it very difficult for the current landowners on the slope. It's way too high. They did what they wanted for their purposes without concern for their neighbors. I don't know how the Phase 2 owners are going to accomplish building that road with a slope that's going to meet engineering standards. It'll be interesting to see. It's not our problem, though. But since you've already let Encompass off the hook, I don't know what you're going to do with the Phase 2 landowner.
I have a question. Did you say that you had an approved access farther up east of the
So
Encompass
we had
entrance?
applied for with the city is we wanted an access on our property.
Right.
That we were going to give Encompass access to. They went in and put in, had competing permits, and FDOT was concerned because when we brought it to their attention, they also said that Encompass had begun building their vertical construction without the necessary FDOT approvals. They hadn't been by the site in a while, and the gentleman's name was Dave McDonald. I believe he's retired, but he was at District 5 at FDOT. So we were working with them, and we said, we'll give you the access you need. They said, it doesn't matter to us. As long as we have the access so we can open on time, that's all we care about. Well, when things weren't working fast enough, they went behind our back and they got the permits they needed to put in the access point they wanted that suited their needs and left us sitting here, and now we're multiple years late on delivering Aldi, and we're not sure if we can even deliver Aldi at all because of the access point. Hopefully we can work it out, but that's for the engineers.
Wouldn't Aldi need their own access point?
Well, they would have the access point via the easement that would be granted over the road that needs to be built. Our problem is their delivery trucks may not be able to make the number of turns that is required now if they enter the access point on the Encompass site. The way we had it, it was a right turn and then straight south to their loading area. They make a left in the loading area.
But wouldn't Aldi need an access point for their customers?
Well, they have access via that point, and they'll have access from Emiliana. Oh, yeah, I mean, FDOT is not going to grant it. The 2 points that we wanted, FDOT said were too close. They could not grant both permits, and the city said, fine, work it out. And, one access point, you two work it out, and it'll be fine. But then we found out in January of 23, without any communication with Encompass, that they had went and received the permission from FDOT to proceed with their access point, which is the one that is now built. And we're left with no connection.
Madam Chairman, obviously this is all interesting to the whole development, but you need to focus on the case that's before you and address this. It's all background information. You made a decision in the Encompass case. You need to look at it as it relates to this case here and as the matter's been presented to you by the city. Again, the PUD applies to all 32 acres of the property. The condition applies to this property, the Phase 2 piece and the Phase 1 piece. If you think the condition needs to be enforced, and you've reached that conclusion, then you would find that there's a violation. If you don't think the condition is clear, then you would move to dismiss this one similar to you did in the first.
Thank you.
Yes, and if I just sort of sum up the city's case pursuant to ordinance 20.
Can you come to the microphone, please?
I'm so sorry. So just to summarize the city's case pursuant to the planned unit development, which was adopted in ordinance 2020-30, and section 3 in paragraph 7, cross access was required to exist. At this point, the city does not see cross access existing, so that is why the violation is being brought.
I don't understand this.
Yes.
Is there an alternative violations in this, or is it's either this or nothing?
Right now, it's this access or nothing.
Well, there is an interpretation as it relates to the road piece that this board, I think, can make. I mean, it's clear that that condition talks about access, right? And the city's position is that meant building and constructing a road? So you're all individuals, you get to look at that language and said, did that include building the road?
The real question is who's responsible to build the road, not whether a road should be built, but who's responsible.
Well-
I think that's the crux of this.
Well, I think if the board was to find, right now, it's probably, given the fact that the prior case was dismissed, you probably are frankly in danger of having what's sort of referred to as inconsistent verdicts or inconsistent decisions, because you'd have opposing decisions related to a similar issue. And so, I'm not sure how the city wants to figure out how to work it out, or the property owners, but it's clear that these property owners are all gonna have to get together and deal with something. Even when they develop phase two, they're probably gonna need to deal with this access area too for the development of that phase.
So I take it ultimately, this is gonna be a civil case, no matter what we decide.
Most likely, sir.
Okay, may I make a motion, Madam Chair?
Please.
I move that case number 250014 be dismissed due to insufficient evidence.
Second.
All in favor? Aye. All in favor?
Aye.
Any opposed?
Nay.
Aye.
Do you vote against it or in favor of it? The chair.
Aye. I voted for it.
For one. And with that, I get the lead. Patrick. You too, Ray.
I just want to thank you all. Appreciate it.
Thank you, you too.
Yeah, I was hitting the button for an hour.
Mr. Brackens, are you ready? I just wanted to make sure. I didn't want to start without you. So this is item 3, case 2310-0021. This is a request for a fine reduction. Property location is 1620 Fifth Street. The owner is Kevin Henshaw. And it was for a building permit that was required. This is the property location in red on Fifth Street. These are just some pictures that were already, again, the case was already presented, and the Code Enforcement Board found this property in violation. So again, this is just a request for reduction. I just wanted to show you at least what the violation was, unpermitted deck. And this is the order finding a fact from the Code Enforcement Board, March 18, 2024, finding the property in violation. The representative of the owner, Mr. Jimmy Crawford, the Esquire, is present. This is his letter requesting a reduction. The owner is requesting a reduction of $300. And I'm not going to read through that. I know it was all in everyone's packet. Showing the hearing notice for today. The case summary, just to give you some background, Code Enforcement Board hearing again was March 18, 2024. It did come into compliance on June 21st, 2024. Of total days in violation were 34 days. The fine total amount owed is $5,100. Staff recommendation is to reduce it to $500. There was a sale of the house last week that Mr. Crawford could actually speak about. The closing was last week, so the owner didn't want any problems with the closing. So he came in after upper management approved it. He came in and paid the whole $5,100, but with the agreement that if you agree to the staff recommendation or his recommendation, that he will receive a refund. So the refund for our staff recommendation of $500 would be the $4,600. If you agree to his recommendation, which is $300, the refund will be $4,800. And that's all I have, and I believe Mr. Crawford is.
Thank you, Madam Chair, members of the Code Enforcement Board. My name is Jimmy Crawford, 702 West Montrose Street, Clermont. Crawford, Modica & Holt is the firm, and I do represent Mr. Henshaw in this, and we are fine with staff's recommendation. It's actually a more, well, I don't want to talk against myself. It's more fair than the 300 because we were 2 days late applying for the permit, and then it was another 2 days before it was marked approved. And the 4 days would be $600, and so a compromise at 500 is more than fair. It was a deck permit that he did not know he had. You know, a lot of people don't know that if you do much work on the outside of your house, you need a permit. And when he did, we had trouble getting a surveyor and getting it done, but he did apply for his permit. It has been cleared, and we appreciate staff's work on it and request your forgiveness of much of that fine.
Does anyone have a question?
Make a motion. In case C 2310-0021, I make a motion that the fine be reduced to $500. I don't think we did any stipulations since it's already paid.
With the direction that the $4,600 be refunded.
That the $4,600 that was paid be refunded.
I second.
All in favor?
Aye.
Any opposed? I'm in favor. Motion passed.
Good evening, Board. Andrew Snodgrass, City of Clermont Code Enforcement. Open up item 5 here. This is case number C2412-0006. This is a fine reduction request. You might remember this one from September. It was rescheduled till November. The code board hearing, the original code board hearing was on March 17th, 2025. The property owner was found in violation. Finding of fact sent out March 20th. The finding of fact was delivered March 20th. The affidavit of compliance was sent August 18th, 2025. This is the finding of facts from the board hearing on March 17th, 2025. The affidavit of compliance the owner received stating the amount of the fine, grand total of 111 days of fines were accrued. This is the owner's request for reduction. This is the second request for reduction the owner sent in. Quick case summary. The case was opened on December 6th, 2024. board set a compliance date of April 16th, 2025. The property was brought into compliance August 5th, 2025, resulting in 111 days of accrued fines. The fine amount was set at a rate of $250 per day, with a grand total of the accrued fines $27,750. Before the hearing on March 17, 2025, multiple emails and phone calls were made to the owner regarding the need for a variance and a permit for the scope of work. She was actually in for a site review and for food trucks that were possibly going to go onto the property. At that time, she was told of the need for a permit or to remove the pavers. The hearing was on March 17th. After the hearing, additional emails and calls from several staff members were made with no response. Variance application was submitted on July 28th, 2025, after staff reached out to the owner. That was 3 months after fines began accruing. Eventually on August 13th, the property was measured and the pavers were removed, so the variance did not go forward. Fines were backdated to when the owner says the pavers were removed on August 5th, 2025. Staff recommendation is to have the fine reduced to 20% of the total fine amount and to have the reduced fine amount paid within 30 days or have the fine revert back to the original amount. The original amount being $27,750. Staff recommendation of 20% would equal $5,550, and 30-day compliance date would be October 15th, 2025. I have nothing further. There is a representative of the property here if you have any questions.
Is there someone here to speak on this property? Thank you.
And she will need sworn in. She did arrive late.
She needs to be sworn in.
Yes. She can speak right up here.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you very much.
If I may interrupt, you're going to speak there. If I may interrupt, I apologize. The 30-day compliance date states October 15, 2025. That was when this PowerPoint presentation was prepared for the September hearing. I did not update that, so that is my fault. It should be December 15, 2025.
Okay.
So, yes, I was here before because I was in violation for having too much pavers on my property. My business that I explained before is I sell pavers. I install pavers for patios, driveways. So from day one, I think there's a misunderstanding or a miscalculation of the pavers that I have in my property. And in the application, I request for an elimination or reduction of the fine completely, because even though I removed what you guys told me to do, I still believe that I was right, that I didn't have too many pavers, and some of what I have already is permeable, and, I feel like it's right to either at least be, reduced to 10% or be eliminated completely, because I believe that there have to be something wrong or something that can be done in my favor.
I remember this case. And it was made clear that the pavers had to be removed.
Because it says that, so if anyone can come in and measure exactly the amount of pavers, where it says that you need to have this amount of paver or not in your property, like what is the calculation of amount of permeable pavers or non-pervious area or paver?
Mrs. Snodgrass?
Yes, so if I may, the notice of violation was for permit or zoning clearance required. It wasn't for the impervious area. The pavers were installed with no approval. So it's not about the impervious area, it was about the zoning clearance required. So, I'm not sure if that helps.
Miss, we're here to consider a reduction in fine and not to relitigate the issue. You've been adjudicated as guilty, and now it is exclusively dealing with how much of a fine you will pay. So you may be disappointed with the finding of being guilty, but that's kind of yesterday's news.
I understand. Would you guys set a fine of reduction to 10%?
Do I have any recommendations, any motions?
In case number CEB C Charlie 2412-0006, I move that the existing fine be reduced to the staff recommendation of $5,550, with the stipulation that the reduced fine be paid to the city of Clermont on or before, what was the date you recommended,
It would be
Mr.
December, 30 days would be December 17th, 2025.
By December 17th. Failure to pay the total reduced fine will result in the fine reverting to its original amount of
$27,750.
$27,750.
Do we have a second? No. Okay. I'm going to make a suggestion. First of all,
And I have one more thought to say. Why would it be so difficult to reduce it to 10% when I know residential is 10 and commercial. My business is not a huge business, I'm the only person in my business. It's a very small business. I don't think having the papers or what I have done is so horrible that I need to be fined this amount of money.
I'm going to work with you here. Just give it a second.
You were a failure to appear at the last hearing when this was originally scheduled.
I apologize, I didn't know that, he mentioned that he had called me or email, but some reason, somehow, and I think when we talked or when we met, I said, I'm sorry, I'm not getting your emails, and then I get them, but then something happened that anyway, they're just, that's excuse, but it's never been my intention to not cooperate or pay or do, or I even gave him the code to my store, I said, come, tell me what do I need to do, and then, we work together that way, he told me, do this, I did it, but somehow, it's just have been getting complicated, and it's not my intention.
Okay. I'm going to make a recommendation rather than December. Why not we make it January 15th? And I'm also going to make a recommendation that we lower it to $35.50. Now, would anybody like to make a motion?
Can I amend my motion?
Certainly.
Technically, your motion failed for lack of a second, so it's available for anybody to make a motion.
Then you can make a motion.
No, I can't.
No.
Do you want to do it?
You do it.
Okay, I'll make a motion. Hold on 1 second. I'll make a motion to, in case number CEB, get the right one, C2412-006. I'll make a motion that the existing fine be reduced to $3,550, with the stipulation that the reduced fine will be paid to the city of Clermont on or before January 15th, 2026. Failure to pay the total reduced fine will result in the fine reverting to its original amount of $27,750.
I second.
All in favor?
Aye.
Aye.
Any opposed? Motion passed.
Moving along to item 5. This is case number C2506-0006. This will be 3853 Falls Crest Circle. Ms. Ross? If you'd like, you can come up to the podium, yes, ma'am. She will need sworn in as well. Oh, I'm sorry, no, she did swear in at the beginning. The city codes are 105-84, section 1853, 1854, 1855, 1856, IPMC 302.2, IPMC 305.1.1, and IPMC 305.4. This is the location of the property for Lake County Property Appraiser. This was a HOA complaint received June 12th, 2025. Notice of violation and abatement were hand-delivered October 30th, 2025. That was a revised notice of violation to go along with the abatement. Notice of hearing was hand-delivered November 10th, 2025. Compliance status as of today's hearing is non-compliant. This is the first notice of violation that was sent out in September. This is the second notice of violation with the abatement sections included in the notice of violation dated October 30th, 2025. This is the abatement notice. It's the affidavit of hand delivery for a notice of violation and the abatement notice. They were posted on the property, but they were hand delivered as well. They were hand delivered and posted at the same time. So that's why they're affidavit of hand delivery versus the affidavit of posting. This is an affidavit of hand delivery for the notice to appear. June 12, 2025. June 12, 2025, a complaint was received regarding a home with a foundation exposed and possible unsafe conditions. The picture was provided with the complaint. This picture came from the HOA complaint. These are pictures during my first inspection. As you can see, the sidewalk is undermined quite a bit. A lot of dirt and soil and earth were removed. No ground cover. Same thing as you can see in the top right, the foundation of the home is getting exposed. And in the bottom part, you can see the foundation and the driveway are being undermined. This is by the front porch of the home with the foundation exposed. Again, same pictures by the front of the property. The right is the front porch and sidewalk. The corner of that is directly underneath the front porch and sidewalk. The one on the left is just in the left corner. I can show you in a different picture where that location is. This is the side of the property. You can see the erosion into the neighboring property and the foundation exposed. This is the back of the property. Since there's no ground coverage, the erosion is just exposing the foundation on the property and washing dirt and soil and earth to the neighboring property. Front of the property, it's August 27th, 2025. This is October 21st, 2025. As you can see from the picture on the right, some earth was removed from underneath the sidewalk. Not the community sidewalk, but the owner's sidewalk while going to her front porch, which resulted in the sidewalk failing and breaking. There's a better picture of that sidewalk. It's October 27th, 2025, showing the front of the property. It's November 10th, 2025. A lot of that dirt has been put back. Not sure on compaction, not sure on level of how tall it is compared to how tall it needs to be. But that yellow paint on the wall is just about right about where the foundation is, where the soil needs to be, about that level. This is again November 10th. You can see still no ground cover. The earth is still lower than the sidewalk, lower than the original grade, lower than the foundation. This is a picture from today, November 17th, 2025. Left side of the property still has a lot of erosion into the neighboring property. The foundation is still exposed. The front of the property still has no ground cover. The soil is not up to the level of grade as intended, as original. This is the city sidewalk, the community sidewalk. The city did cone it off and block it off, but it is, with no ground covering around there, it is being eroded and will possibly fail soon. Quick case summary, complaint was received on June 12th. The first inspection was June 13th. The police department was called to the property over 80 times in a year for a situation at the property with the neighbors putting stuff on the ground and the owner removing the soil. PD Community Assistance was in contact with family members but are unable to provide further assistance at this time, so the property began to get worse with more dirt removed from the property. Community sidewalk complaints were received. In October, the HOA became involved a little more and have requested a mediation with the owner. The owner has filled in the holes by the front porch, but the grade level is still below the foundation. Staff recommendation is to find the respondent in violation of the section stated and to approve the city's request to abate the property to resolve the violations. I have nothing further. If you have any questions of me, also the homeowner is here to speak as well.
Before the homeowner speaks, I just wanted to clarify, so the city is looking for an order under section 1893 instead of 162? Or are you looking for both a 162 order and an 893 order?
1893.
The city's, has issued a notice of abatement. Basically, they're asking to go onto the property and
Gotcha.
abate the hazard.
Understood. Thank you.
Did this soil just, was it erosion, or was it actually dug up and carried away?
The property owner removed. The property owner removed it. She can explain.
I didn't realize. Could you please just state your name and your address, please? Mm-hmm.
At 3853 Foster Circle,
Thank-
Clermont, Florida, 347.
Thank you.
I didn't realize what was going on at the house. When I look at it now, the neighbors were always in the yard. I was always calling the police. But I didn't realize why they were always in the yard. Now I see they were tearing my yard apart. And they were always in the yard. And I was always calling the police. And now I see it. Now it comes together. We were feuding. So what they were doing, they were taking my yard apart. I see it now. They still freaking coming in, still in this case. I didn't know this was going on. I just knew they were always in the yard.
Do you live on the property?
Yes. Yes, that's my only home. I love my home. I didn't realize it was here. I know they had I know they were still in the grass. I know they were putting, I see weeds all in the backyard, and I always said, okay, I'll get back to that. But I didn't realize that they had done so much. They were always in the yard. The police officers say I called them like 70 or 80 times. And I didn't realize what they were doing. When the new neighbors moved, they're here now, I have a hill in the backyard. And he would always come over and, like I would try to block the dirt from rolling off, he would always come over and get it to run off so that it'll run off the little hill. He was always, he would remember when the rain would come, and he'd run over there, and the dirt would run off. And it was just constant. And I just see what was going on in there. I'm just seeing that when I see those pictures, because I didn't see the house like that, because you're seeing it in pieces. And they were always there, so that's what they were doing when they were always there. And then the police officers, they stole my grass, they Baker acted me, and that just hurted me because there was nothing wrong with me, because I was calling them all the time. And I was calling them all the time because they were in my yard. That's why I was calling them all the time. And so now I see, and even now, they're still in my yard. Even now, they're always there.
Thank you.
And so just for the benefit of the board, the city is requesting a motion under number 15 under nuisance abatement, not under the normal 162 motion.
And what does that mean?
That means they're proceeding under That means they're proceeding under the nuisance abatement section of the Clermont Code of Ordinances and section 893.138 Florida statutes instead of 162, which you typically hear for regular code enforcement violations. So it's number 15 in your packet.
Now, there's one thing I just want to understand to make clear for the record. When you mean the city wants to abate it, exactly what does that mean?
That means under the statute, it's different. So in a code enforcement case, you give them time to come into compliance.
Right.
If they don't come into compliance within a certain amount of time, then the fines begin to accrue. Under this section, it's $250 a day beginning from the date of your order until they abate the nuisance.
I see.
Madam Chair, may I make a motion?
Do we have anyone else who wants to speak on this matter?
Based on the clear and convincing testimony and evidence presented in nuisance abatement for case number CEB C2506-0006, I move that the city has proved a sufficient number of allegations in the nuisance complaint and that an unlawful public nuisance has been established. I further move to order that the respondent stop the nuisance. In order to comply with this order, the respondent shall take the remedial action set forth in the petition or other such steps as determined or listed by the board. Based on the finding of a nuisance pursuant to section 893.138 parentheses 11 Florida statutes, I further move to impose a fine of $250 for each day the public nuisance continues beyond the date of this order, and for an award of reasonable attorney fees and costs incurred by the city for bringing this action. If necessary, the city may come back before the board upon notice to the respondent to quantify said award. By my motion, I further direct that the city to record this public nuisance order so that the notice may be given to all subsequent purchasers and successors in interest or assigns of the property at issue. I further move that the board retain jurisdiction over this matter for 1 year from the date of this order to ensure compliance herewith.
Do I have? We,
Supposedly gone now. The reason I haven't replaced it, he steals it. I replaced the side and all that's gone.
ma'am, we're in the middle of a motion. Thank you.
If I may just clarify, the city's seeking, so we did a notice of abatement for the respondent to abate the nuisance. Now the city's just asking permission to go onto the property and do the repairs necessary to abate the nuisance. So that's under section 1853. Yes.
So I add to my motion that under section 1853 that the city be permitted to enter upon the property.
If they pass the motion and the order passes, that the city can go onto the property to abate the nuisance and put the charge back to the property owner for the cost of abating the nuisance.
But nobody cares that my guts get stolen. I replaced the side, he stole it. I replaced the front, he stole it. That's why I haven't done it.
This is where we are today, ma'am, and we just.
Nobody cares about that.
Do I have a second?
Second.
All in favor?
Aye.
Aye. Any opposed? Motion pass. Motion pass. The city is gonna come fix your property.
What does that mean? And then you got to build?
Most likely.
Why you say most likely? I'm sure they didn't do it for free, right?
I'm not in charge of that, ma'am. You have to
It's
speak.
not that I don't know, he steals it.
Thank you.
I'll send you the paperwork and that's all.
I mean, I can pay for it myself. I can do it. I just have.
was item number 6, case 2507-0007. Property address is 1326 East Avenue. The owner is Grupo Cinco LLC. This is Josh Cortez's case. I am the complainant, so I am involved in this case, but he couldn't appear today to present it. So I do have quite a few notes from him and emails as well. The city code and international property maintenance code violations would be 108.1, stop work order, the authority for a stop work order. Section 125, 522, subsection A, which is building permit required. And that's the definition for the stop work order and the building permit required. This is the property locations off of East Avenue in between Seminole and Linden Street. It's in red. The case summary, I did drive by and I saw the issue right away, and I got a hold of Code Officer Josh Cortez, who initiated the case. Notice of violation was sent July 10th, 2025. The compliance date is August 10th, 2025. Notice of violation was posted July 10th, 2025. That's when the stop work order was initiated. The notice of hearing was sent on October 14th, 2025, and both violation and hearing notices were posted on October 23rd, 2025. As of today, it is non-compliant. And this was the notice that Josh Cortez sent with the affidavit of posting, because the owner was not on site when I initially observed the violations and when Josh tried to make contact. This is a hearing notice sent with affidavit of posting. And these are pictures back in July 10th, 2025. What appeared to be a rehab, remodeling. We got a hold of the building department right away, and per the building official, the previous building official, we did a stop work order. And this is what you call level 3 alteration per the building official. Just showing you the stop work order placed on the door. And this is an email from the previous building official to Josh, just going over some of the requirements based on more than 50% of the building area has been altered. So it was subject to the conforming of the building codes required below, which is 901.2 compliance, 105.1 required, and the inspections. And he also put that it was apparent amount of unpermitted and uninspected alterations performed. This is the owner, days later reaching out to Josh when he went to the property, saw the stop work order, got a hold of Josh Cortez, but he was referring to the only permit that we had on file, which was for a roof permit, and that's what this email is about. So Josh is explaining to him, this is not about a roof permit, this is a complete remodel, and there was no permit on file, no plan submitted. And this, again, just Code Officer Josh Cortez, again, explaining, elaborating a little bit more to the owner that this is a level 3 alteration per the building official and what was required of him to, get the plan submitted at that time. And he did advise, and he reiterated not to have any contractors come back and do any more, work until a permit has been issued. And this is Josh taking pictures on the inside with the permission of the owner when they met. As you see, it's not just one room, it's basically the whole house. Let me know if I'm going too fast. Now plans for this remodel was received. This is a 1924 residence, just so you know. That's why there's a lot of upgrades that need to happen. But it did go through the intake process. It was rejected back in November 7th. So this has been going on for months, and just November 7th, everything that was submitted through intake, not even through the review process, was rejected. And the owner is here as well to present his case. And that's just showing the picture of the posted, both notice of violation and hearing in front of the property. They have not done any more work since. This is just showing the building application. And again, this was rejected, and there's just a lot of documents that need to be submitted. They need to complete and notarize a building permit application, provide property record card, sign and seal engineering plans, so on and so forth. All that information is in the system for the owner to see what he needs to get resubmitted. Again, still has to go through intake, the review process, before a building permit is approved, then issued. And that's what we're looking at. We want it in hand, issued. That way it's, they're doing the work performed correctly.
May I ask a question, please?
Yes, ma'am.
So the issue here, besides they don't have a building permit, they don't have all the paperwork necessary in order to obtain that building permit?
Correct.
Okay.
Staff recommendations to find the respondent in violation of the section stated, to assess a fine of $150 per day every day that the property remains in violation after December 1st, 2025. Do you have any questions? And I know.
Sir?
May I ask just one question? I noticed
Yes,
there were
sir.
a number of subcontractors, I guess you would call them, on the permit application. Were those, and it looks to me like the electrical work has already been done. Are they licensed contractors?
That's all through intake, and because it's still getting reviewed and it was rejected, that's probably one of the approval sheets that for the building code. There's windows, doors, there's a lot of product approvals that have to be submitted, so that could possibly be for the electrical as well, because there's a lot of electrical, mechanical, everything going on, and he could probably produce some more information as to that.
Okay. Sir, could you state your name and address, please?
Good evening. My name is Andres Torres. I don't speak English. I'm so sorry, but I'm going to read awards. Okay? I'm the Grupo 5 agent owner to 1326 East Avenue. I am foreign and I come today directly from Colombia, where I live to show to a disappointment and show my interest the things in the right way. I'm aware and understand the current situation. When the property was bought, I trust other people to make the repairs of the house, and obviously they didn't do it well. As soon as we're notified, I completely stopped to work at the house. I already have the plans developed by a certified engineer, and some way certificate general contractor requests the necessary permits in the city to complete the repairs in the correct way. The permit is 255101. I'm so sorry, my English.
Okay.
This is the plans, this is the permit.
So have you submitted any of the paperwork yet? Do you have anything submitted?
Well, he does have some submitted, but again, it got rejected. It was rejected on November 7th. I could read exactly what was rejected. Complete a notarized building permit application, property record card from the property appraiser, sign and seal engineer plans as a singular PDF document.
Could you just slow down a little bit?
Oh, sure.
Thank
Product approval sheets for Florida building website for windows and doors, map of the property, product approval for single gun window supplied to from the old version, supply plans for a new AC, and provide an existing floor plan. And it also shows in some of the details that the sub was not registered. They need to register.
Okay. And when you say map of the property, you're talking about a survey?
Correct.
Okay. You have stopped the work? There's no more work going on? Okay.
I'm wait to city or continue.
Do you understand all the necessary paperwork that you need? Do you understand what you need?
I'm sorry, I don't understand. Sir,
Can you-
I can swear you in to translate, you just have to be able to swear that you can translate accurately. Would you be willing to do that? Would you be willing to do that?
No, only one annotation. The permit is because
Wait.
Huh.
We have to do things a certain way.
Yeah,
Number one, you have to say, are you speaking for this man? Are you speaking for him? Okay, very good, very good. Now,
yeah, in order for you to translate for him and explain, I need to swear you in.
yeah,
Okay. Do you swear or affirm, please raise your right hand. Do you swear or affirm that you will translate accurately for the record? Thank you.
wait, can you speak your name and address, please?
my name is Sergio Salazar. The permit,
No, your address?
my address?
Yes.
Okay, is 50467 Shorewalk Drive, Winter Garden, Florida, 34787.
Thank you.
The permit, the only problem to this.
Are you translating or are you providing testimony?
Spanish?
No.
No, only one point. The permit, in this moment, the problem is the format, the planes is different in this moment. Shane today, tomorrow is in online, is in the city. Tomorrow is all the plans in the city.
Okay.
So, I was wrong. That you're not translating, you were providing testimony. So, I gotta ask you I gotta swear you in to testify. Please raise your right hand. Do you swear or affirm that the testimony you just gave and that you will give is true and accurate?
Yes.
Thank you, sir. Go ahead, sorry.
Can I just ask, what is your role in relation to the property? Friend?
And just for the record, because he was away from the mic, that gentleman testified that he was speaking on behalf of the respondent as his friend.
Thank you. Okay.
And I would like to reiterate, this is an LLC, even though he's the owner. So this is a contractor who knows what's required by law. The contractor and applicant, Gustavo Ramirez, was the one who submitted these plans that were rejected. And this has been ongoing since July 10th, 2025. The good thing here is the work has stopped, so that they have done for us. But when we met with the contractor, when we met with everybody on site, I mean, this is a contractor who's very well aware, who's an LLC, who knows what needs to be submitted, license and all, and, you know, it's on East Avenue. I mean, it's pretty close to 50. I was actually really amazed, all that work that was being done, and no one really called it in. So, because it's a safety concern, that's when, you know, we went ahead and did the stop work order. The time that it has been now months for them to submit and everything is getting rejected, you know, to our knowledge, an LLC should know exactly what paperwork or documents to introduce. I could definitely provide this to him, you know, if he doesn't have the notes, it's all in our system. That is not a problem. I could give him my business card and we could email him that, but he should have all that information, or at least a contractor on file.
I'd like to make a motion if I can.
Okay.
That's it.
I'm also going to make a recommendation
Okay.
that because of the fact that this gentleman has an issue with communicating and understanding things, I'm gonna make a suggestion that we give them to, you had December 1st? You wanted,
Yes,
I'm
ma'am.
gonna make a recommendation to extend it to December 15th. That's just my recommendation.
I need to make a motion.
Yes, sir?
Based on the testimony and evidence presented in case CEB, Charlie 2507-007, I move to find the respondent is in violation of the City of Clermont's Code of Ordinances as listed in the notice of violation filed in this matter that I have considered. 1, the gravity of the violation, and 2, any actions by the violator to correct the violation, and 3, any previous violations by the violator. I move to order that the respondent correct the violation on or before December 15th.
Yes, sir.
In order to correct the violation, the respondent shall take all or take the remedial action as set forth in the notice of violation. If the respondent does not comply with this order, a fine of $150 per day will be imposed for each day the violation continues past December 15th. The respondent is further ordered to contact Code Enforcement Office for compliance and to arrange an inspection of the property to verify compliance with this order.
Do I have a second?
Second.
All in favor?
Aye.
Those opposed? Motion passed.
Evening again, board. Move on with item 7. Case number 25-000044, 3224 Sailing Pier Avenue. City Code Section 125-522, building permit required. This is the location of the property via Lake County Property Appraiser. A quick case summary. Is in-house complaint from our chief building inspector. Notice of violation was sent out August 12th. Compliance date was September 30th. A notice of violation was posted August 19th. Notice of hearing was sent October 1st. And a notice of violation of hearing posted October 1st, 2025. So the notice of violation on the left, the affidavit of posting on the right. The notice to appear and the affidavit of posting. This is an email from the chief building inspector requesting code to investigate work without a permit. There are 3 pictures attached as well. The email from the chief inspector advising what scope of work the permit should cover. Basically, stating that they'll need a structural engineer to verify everything that was covered, and electrical contractor and mechanical contractor to verify and certify the installation as built. So approved plans for the initial construction show an open lanai in the back of the home. The plans examiner, Robert Tabeos, confirmed the plan details specify an open lanai. While the chief building inspector, Larry Schmidt, was on site for a pool inspection, that's whenever the lanai was noticed that it was completely enclosed. As you can see, the 4 sliding doors on that lanai. See, it's enclosed there. Satellite imagery from Lake County Property Appraiser shows the open lanai after the home was built. This is just showing the posting in front of the property, as well as the permit for the pool. It's a building permit application for enclosing the lanai. The building permit application was received on 10/14/2025 and was rejected on 10/16/2025. It was rejected on intake. There were no documents submitted with the application. It was simply an application of this is what I would like to do. Staff recommendations, find the respondent violation, to assess a fine of find the respondent violation of the section stated, and to assess a fine of $150 per day for every day the property remains in violation after December 17th, 2025. Nothing further. If there are any questions for me, this is Officer Cortez's case. I'm just speaking on his behalf.
Okay, I do have a question. The building permit was submitted after the lanai was enclosed?
Yes.
So therefore, there would be no inspection or anything because it's already been closed, so you can't do inspections for the wall?
Correct. That's why the chief building inspector did send an email to Officer Cortez stating that you would have to basically have an engineer open the wall and see what was covered up, see what electrical work was done, what type of structural work was done to enclose that lanai.
So you understand why you weren't given a permit because it wasn't inspected before the walls were closed?
That's not the reason for the permit denial.
Oh, okay.
The reason for the permit rejection was that no paperwork was submitted. It was just basically an application stating this is what I would like to do. So that there was no property record card, there was no plans, there was no survey, there was no subcontractors, no permits for electrical, which would be separate from the building. There was nothing submitted other than an online form stating I would like to enclose my lanai, and I can show you exactly what was. This is the only paper that was submitted.
Officer Snodgrass, and
Yes.
the violation is for performing work without a permit, correct?
125-522, I believe it is building permit required. It was the notice of violation. But yes, the work was done without a permit.
Okay. Sir, could you state your name, please, and address?
Good evening, board members. My name is Marlon De Carvalho. I'm the owner of the property 3224 City Beer Avenue, Winter Garden, Florida 34787. And as soon as I received like the first notice, I got contacted the contractor that built the sliding doors and enclosed the lanai, and I have request him like to like fix the violation, like send and request like all the permits necessary like for the work that he has done. And he said to me that he already like working with the city like for the permits, and he said like the city like requires like more drawings, and he's working like currently with the engineer like to get the drawings like to give to the city. I have some papers that they sent to me. Would you like to add?
If you'd like to add them, we can make copies of them and provide them to the board members and the clerk.
Okay, good. So they have to provide to you?
I have a question. So we tend to use the word contractor loosely. Is he a licensed general contractor in the state of Florida?
Yeah.
So are you certain of that? Because he would know what would be required. And it's something that should have been discussed to begin with. So you had no knowledge that you would need any of these
No.
permits from him?
Yeah, it was like, when I, because the house, I built the house. So we moved, from Texas to here, and the house was in a build process. So when I got the keys, I got them contracted, like to enclose it online. And, I didn't know that the permit, it was required only for the sliding doors. So that's why I didn't ask for the permit, but I think like, it was my fault, and it was my fault, and I think like his fault as well, because he's, as a general contractor, he should know that the permit it was required.
You are correct, and unfortunately, it's you that's standing in front of us because you own the property and you hired him. Even if you went to Home Depot to get doors put in your house, they would pull permits.
Yeah.
That's all. I just.
Yeah, I apologize, I didn't know about that.
It just clarifies something in terms of the legality of this. If a licensed contractor does work, it's still the homeowner's responsibility, or is it not the licensed contractor's obligation to pull a permit?
The contractor has liability, but under a different Florida statute and from a different agency. Here, it's the homeowner who is responsible for it, and violations run with the land owned by the homeowner.
Okay.
And what is the staff recommendation?
The staff recommendation is to fine the property in violations of the section stated and to assess a fine of $150 per day for every day the property remains in violation after December 17th, 2025.
Well,
Ask another question, ma'am. Can you provide the name of the contractor that you engaged? Give it to code enforcement so that they can verify that he is a licensed contractor?
Should I like provide right now?
If you have it, maybe.
I believe it's right here on the second page. Oh, okay. Okay.
His name is Bill Vasquez. Construction Service of Orlando, LLC.
Thank you.
Well, I'm gonna make a recommendation. I hate putting things into, December right around the holidays. I'm just gonna make a recommendation to move this to, January 17th instead of December 17th. That's just my recommendation.
I have, so the document that you have here is just a statement from an architect stating that he believes that the work that was done is sound. Do you have any, have you submitted, is this same architect going to draw the plans and everything? Because I think that was the question, which is why your permit was denied, because you just requested a permit instead of submitting the plans, the scope of work, a sealed set of blueprints from an architect, and things like that. So you have that in motion, correct?
Yeah, I can like explain to him, I don't know if this was like explaining like to the contractor before.
If he's a licensed contractor, he should be very well aware of what the requirements are.
I can talk to
Yeah.
him
Yeah, 'cause
blueprints and everything like needs to be sent.
one of the things that's important, and the reason why we have building codes across the entire country, and every state and county has different codes, so whenever you move or go somewhere, you gotta go to the town and find out what type of codes, building codes, that they require. But one of the main reasons why codes are here is to make sure that work is done properly, so when you pay for work, you get what you were told, and that it's done properly, so this way, no injury can come to you, no walls will collapse, no electrical fires or anything. That's the whole reason why it's here, is to protect you. That's the reason why. And my concern, which, first of all, I'm gonna ask, was there any electrical added into that, lanai?
It was from outside.
Okay, see, that's another issue, because make sure that you get, electrician who did the work. They have to be licensed, and that has to be submitted to the town. Depending on the building department in the town, how they're going to handle it, it's up to them, but
Let me
from,
add something, so if the walls was not built after, so it was only the sliding doors. So I have the lanai, my lanai is still there, so since when I bought the house, when I built the house, the lanai was there. So nothing was changed regarding the lanai. I only like put the sliding doors.
doors in, that's it.
I only close with the sliding door, so all the walls, everything was
else
there,
is
so.
still the same.
Yeah.
Okay.
By the builder, it was not anyone from there that touching on the walls. So
Okay.
the walls was there like since the beginning, since the day one. I had all the walls and
The
the
roof,
ceiling,
yes.
the roof. So I only contract them like to put the sliding doors.
Okay.
That's it.
So, but my comment to that would be, based on the picture that was shown, the back section of the lanai was wide open. That sliding glass door, that lanai is probably 12 feet wide. So you have two solid pane and two sliders that open up. So there would have been at least studs added on
Yeah,
the side
it
to
was
enclose.
only at
Yes.
The right side. So
Yes.
the left is already there. So only the right one. But there is no like why is there is nothing there.
But you still need permits. Like that's
Yeah,
why we're here for
I
the.
know that I need permits, but the only thing that I want to add, that is regarding the electrician or something like this, that is nothing like there was like did by them. So all the conduits, all the wires inside the wall, it was from the builder, not from my contractor. The contractor only installed like this lighting door.
But you're here with, like, that's not, we're not here to decide what you added or didn't add. We're here to just rule on what they saw, which is you closed in the lanai, whether it's 3 walls or 1 wall, you closed that portion in without a permit, and that's what we're being asked to rule on. The recommendation for you was to make sure that you're dealing with a licensed contractor, because a licensed contractor would know exactly what you needed, and you wouldn't be standing here in front of us. So, that's the only thing I think that everyone's saying.
Yeah, I think that is something like good to add, because I know that they will, my contractor will like send all the documents like requiring the permit. So that's what I need, so just before January to not pay any fine.
Okay.
So, but the thing that I want to add here, that is no walls like built at that time, so it was only the sliding doors. So I know that they will like send everything that you guys like requested, but regarding the sliding door, there was added there.
Okay.
What I'm trying to explain.
Okay. We understand. We just want to make sure that you understand you get all the proper paperwork and submit it to the town, so this way that you can move forward and remove the violation. Okay? Do I have a motion? That's what the staff suggested. I made a recommendation for January 17th. Yeah, that's that's my recommendation.
So that would be number 5 ordered. So that would be number 5 ordered guilty? Based on the testimony and evidence. Based on the testimony and evidence presented in case number 25-000044. I move to find that the respondent is in violation of the City of Clermont's Code of Ordinances as listed in the notice of violation filed in this matter, that I have considered the gravity of the violation and any actions by the violator to correct the violation and any previous violations by the violator. I move to order the respondent correct the violation on or before January 17th, 2026. In order to correct the violation, the respondent shall take the remedial action to set forth in the notice of violation. If the respondent does not comply with the order, a fine of $150 per day for every day the property remains in violation after January 17th, 2026. The respondent is further ordered to contact Code Enforcement Office for compliance and to arrange an inspection of the property to verify compliance with this order.
Do I have a second?
A second.
All in favor?
Aye.
Aye.
Any opposed? Motion pass. You have to January 17th.
Yes. All right, moving on to item 8, last item of the evening. It's case number C-2503-0021-1660 Drew Avenue. This is again 125-522, general development conditions, building permit required. This is the location of the property via Lake County Property Appraiser. This is a citizen complaint. Notice of violation was sent April 14th, was signed for April 17th. Notice of hearing sent September 9th. Notice of hearing signed for September 11th. As of today, the property is non-compliant. The violation notice dated April 14th. This is the notice to appear. It's the U.S. Postal Service receipt for the notice of violation and for the hearing notice or notice to appear. This is a picture of the back of the property, the deck, underneath the deck, a lot of the railing. There was a lot of work. The full scope of work is unclear at this time, but there was a lot of work added to this deck. See in top left and the bottom right shows pretty much all new boards underneath, structural posts. I don't believe the aluminum structure was new, the screening was. Just showing a little more of the boards, the new work. Again, that's the only picture I have of the property, so I apologize for that. I did speak with the owner and contractor on March 28th, 2025, made them aware of the need for a permit. The contractor was on site and stated he would get the owner straight with the city. That's what he told me. June 18th, the contractor stated he was working with a local engineering company and should have the plans within 2 weeks. That is the last I've heard from the contractor. Or no, I'm sorry, August 4th was the last contact with the owner via email until recently. The contractor was June 18th for the last contact. The owner did leave me a voicemail on October 31st stating he received a notice to appear and was asking if the contractor has pulled a permit. I did call Mr. Anderson back, left him a voicemail, letting him know that no permit has been applied for the deck. Permits pulled in 2025 include an electrical permit that was pulled in April, windows and doors that were pulled in May, and a fence permit pulled in September, but nothing for the deck. As of today, no application has been received for the scope of work completed. Staff recommendations, find the respondent in violation of the section stated, to assess a fine of $150 per day for every day the property remains in violation after December 17th, 2025. I did speak with the owner a little bit before this, and I believe his contractor does have engineering plans ready to submit. I have nothing further if you have any questions. I have nothing further if you have any questions for me. This is the owner who can speak as well.
Benjamin Anderson, 1660 Drew Avenue, Clermont, Florida, 34711. As you can see, the contractor has promised a lot. I wish that I had his contractor number. He used the word contractor, and I would assume he does, but you know, the lawyer says, well, you know, what's his number? I'm like, yeah, that would have been good for me to get that number. But the contractor assured me at the time of the work that I did not need a permit. And you can see I always get permits. And he assured me that he knew because there were no added structures. It was just, you know, that, you know, he did add on to the existing structure. He renovated the whole deck. The deck was 10 years old. He renovated. He said, I don't need a permit because all those posts, I'm not putting in any new posts. So I was relying on his knowledge as a contractor. But he promised me he'd be here tonight to represent me, and he's not. And he told me that he was working with Bobby Poole. I don't know if anybody knows Bobby Poole. Nobody? I was just hoping that maybe somebody had his number so that I could contact Bobby Poole. Because Bobby Poole came out, he took pictures and he did drawings of the deck. And I had, you know, like maybe an 8x10 addition to where, you know, the existing structure was here, okay? And so it had a deck outside, so I just opened up the deck and put, you know, a screened area. And okay, if I need a permit for that, great. So Bobby Poole came out and he said, hey, you know, I'll get right on this. But apparently this contractor that I was using, he pulled him off my case for some reason, I don't know. But what I would do going forward, I'm just asking for a little more time. Because if I have to do this myself or contact other people, it's just gonna take me a while. I would just ask for, if we could just do it until maybe January. I mean, that would give me a chance to contact this guy, the contractor, and say, hey, you know, what did Bobby do for you? I mean, you said that he was gonna satisfy the permit problem before this hearing date. And so my last contact was on last Friday with the contractor, and he said, hey, I'll get everything ready, it'll be done by Saturday. Bobby's ready. He's got everything done, and we'll just present it on Monday before the hearing, and you'll be all set. So all I'm saying is, I don't think I can make December 17th. If it's gonna go back on me, and this guy was just BSing me from like when, April. I mean, I don't know. I mean, Bobby Poole did come out to my home, so I did see Bobby. I spoke with Bobby. Hey, everything's gonna be great. But so I just don't know what to really think, other than hopefully tomorrow he's supposed to meet me here, so I'm kind of at a loss, you know. So December 17th seems like it's gonna come up here pretty fast. So I don't know, I'm just asking for maybe a little more time, because he caught me off guard. He promised me he'd be here, and, he's not, and, we got holidays coming up.
I have a question.
Yeah.
This is to the staff. In order to get the building permit, what is
You would need engineered plans. You would need engineered plans.
is that all he needs?
As far as I know for the scope of work, yes.
Okay, at this time, you're gonna need engineering plans.
Which I believe he has Mr. Poole working on, correct?
Yeah, but if he does, I mean, this
Okay,
guy's been
but
working on it since
I
April.
understand that, but at this point in time, unfortunately, like you said, he's not here, but you are, and this is your property,
No,
so.
that's what, I know,
yeah,
I
so
understand
you're-
all
you're-
that,
you're-
totally
So
understand
what
that.
I'm going,
I'm just asking for maybe an extension of December 17th, could possibly be January 17th.
okay.
That would be, because I'm.
Would you
I
be
don't
fine,
wanna-
would you be fine with January 17th? And with the understanding that if you don't have the paperwork submitted, and you're not in compliance with a building permit, you will receive a $150 fine per day. You understand that, right? Okay. And you're satisfied with January 17th?
Well, hey.
Listen,
If
they're
you're
rec-
saying, if you're saying that's the farthest out you can go.
Yes. This will,
Well, then,
that gives, you're getting 2 months. Okay? You have November, you got December, and then we're going into January. So
all right, so. if
I'm
I-
gonna make a recommendation, and I can only make recommendations. And it's up to the rest of the board to make a motion and to vote. So with that said, this way we can move forward and you can, do what you need to do. I'm gonna make a recommendation that, we change the date from December 17th to January 17th, 2026. That's my recommendation. Now I'm gonna ask, do we have a motion?
Make a motion. Based on the testimony and evidence presented in case number C-2503-0021, I move to find that the respondent is in violation of the City of Clermont Code of Ordinance as listed in the notice of violation filed in this matter, that I have considered the gravity of the violation and any actions by the violator to correct the violation, and any previous violations by the violator. I move to order that the respondent correct the violation on or before January 17th, 2026. In order to correct the violation, the respondent shall take the remedial action as set forth in the notice of violation. If the respondent does not comply with the order, a fine of $150 per day will be imposed for each day the violation continues past January 17th, 2026. The respondent is further ordered to contact Code Enforcement Office for compliance and to arrange an inspection of the property to verify compliance with the order.
Second.
All in favor?
Aye.
Aye.
Thank you. Could I ask does
Motion
anybody-
passed.
Thank you. Does anybody know Bobby Poole?
This is public information.
Okay.
DVPR is your best friend. Go home right now or get on your phone.
Okay.
Go to the Department of Business and Professional Regulations.
Okay.
Look up their names and they'll tell you if they're licensed. That's who licensed general contractors, architects.
And DBPR is also a online forum where you can file complaints against contractors who don't pull permits or who are unlicensed at the time, expired licenses. Joseph with Ocala Customs is who you had do the work, correct?
Yeah,
Yeah.
he changed his name.
I've tried to look him up, I can't find him, so if I can get a last name, if you do find a last name, I'd appreciate it. If I find one, I will let you know as well.
Okay. Thank you.
At this time,
One update for the board. As one update for the board. Our
Yes,
next
sir.
scheduled meeting Our next scheduled meeting is January 19th. That does fall on MLK Day. We are closed here for Martin Luther King Day. At this moment, I do not have an updated date. We will be sending you that probably within about a week. I have to wait for council to form to find out if they're going to have any other possible workshops that week or not. Once I know that, I should know that later this week. Next week, you'll get an email for our updated time. We try to get between that Monday, Tuesday, possibly the next week. I gotta wait to find out what their schedule is first.
Okay, so as of now, it's tentative as January 19th?
That would be our normal third Monday in January. Yes, the 19th. That's definitely going to be canceled.
Okay,
Yes.
okay, thank you. Is there anyone that wish to come forward to speak?
Public comment?
Yes. Public comment, anybody? Okay. Do I get a motion to adjourn?
I move to adjourn.
Second? Second. All in favor?
Aye.
Aye.
Motion passed.